Indian Legal Thought, Mahatma Gandhi University. My colleagues at School of Indian Legal Thought, Mahatma Gandhi University. The UGC Stride family of Mahatma Gandhi University. We are honored to have Professor Dr. S.K. Bhatnagar with us today to render valedictory address to this UGC Stride short-term online course on law and social transformation, contemporary issues. It's my proud privilege to welcome you, sir, Professor Bhatnagar, sir. He's a renowned, as all of us know, he's a renowned legal luminary. Has given outstanding contributions as far as legal education is concerned. So he was a former Vice Chancellor of Ram Manohar Lohia National Law University and also Ambedkar Law University, Lucknow. As we are a group of 362 registered participants, along with the 40 students of School of Indian Legal Thought, which makes 402 participants, Professor. And the esteemed participants are from different parts of India and comprises of law teachers, the PG students, and the UG students of law. So together we went for the past 12 days, and this is the final day of our short-term program. So warm welcome to you, sir. And for the formal welcome note, I invite Megha Mariam from the first semester LLM student of School of Indian Legal Thought. Megha?
Yes, ma'am. Thank you,
Yes.
Bismi, ma'am. Good evening, everyone. I am Megha Maman, first year LLM student of School of Indian Legal Thought. This is the last day of our 13-day journey of learning UGC Stride online certification course. It's my great pleasure to welcome you all to this ending day of our webinar. Today, we have the privilege of hosting Dr. Professor Subir K. Bhatnagar, sir, former Vice Chancellor of Dr. Ram Manohar Lohia National Law University, Lucknow. On behalf of the entire participants, I officially welcome Professor Subir K. Bhatnagar, sir, for the valedictory address on democracy, social justice, and Indian Constitution. Welcome, sir.
So please, sir, please.
May I start?
Yes, sir. Yes, sir.
Okay, thank you very much. Am I audible?
Yes, sir. Yes, sir.
Okay, thank you. Professor Bismi Gopalakrishnan, you have given me this unique opportunity to participate in UGC Stride course organized by Department of Lifelong Learning and Extension. And it's an online certificate course on law and social transformation, contemporary issues. I welcome all the participants also. Now the title of my address is relating to three things: democracy, constitution, and social justice. So I start with constitution. Is there any need of having any constitution? And what is the role of the constitution? Traditionally, if we begin with the American Constitution adopted in 1789, the role of the Constitution is to provide for the powers of different organs, that is, legislature, executive, and judiciary. Nothing more than that. But in the American Constitution, later on, Bill of Rights were also added. Certain rights were added through that Bill of Rights. And there were amendments, as you know. So from then on, it was accepted that a democratic constitution must provide for individual rights also, but there was a reasoning behind having rights in the American Constitution, because the idea of the United States of America was that there were 13 states which came together to form what we now call the USA. The main focus was pursuit of happiness and protection of individual rights. Then we come to our Constitution. Our Constitution does not stop only on providing the functions of different organs of the state and providing for the rights. It goes further. Why it is so? Because if we go back into the history of making of the Constitution, it didn't begin in 1946. It had started, if I can take a convenient point, when Motilal Nehru Committee report was submitted in 1928. We were under the British rule, but Congress was fighting for the independence of country, and Motilal Nehru Committee report had made it very clear that if India becomes free, we will have a constitution, and that constitution will be in the name of the people of India. That is, the source of power will be the people of India. The rights will be protected. And then they were not fighting for only political emancipation. They were fighting for social emancipation also. So we will provide for social reformation also, social transformation also. So the question arises whether a constitution can provide for social transformation. So the answer is yes, it can provide for that. Can the constitution delineate the attributes of social transformation? What will be the elements of social transformation? In what fields it is to be carried out? That can be done. And if you look at the chapter on Directorate Principal State Policy, it's very clear that different attributes through which we can identify that social transformation has to take place, they are mentioned there. Then next question may arise whether the constitution can prescribe the path, the mode of achieving that particular transformation. In other words, whether it will be democratic or non-democratic, because social transformation can take place in non-democratic state also, non-welfare state also, it is possible. So what we are going to have? So that is written in the preamble that we will have a democratic republic. So social transformation through democracy. Now, what is social transformation? Now, it is to be differentiated from a revolution. Revolution does not have any kind of a path, and it doesn't have any constitution. It is not silent. Though we know about glorious revolution in United Kingdom. But traditionally speaking, revolution is coupled with some kind of violence. If there is no violence, then it is not a slow and gradual process. But in case of transformation, there is a slow and gradual process. Now, what was the motto for social transformation? What was the goal? So social justice is the yardstick of social transformation, because transformation must be targeted. It must try to achieve something. So we can say social justice is the lodestar, is the goal, is the yardstick through which we can measure whether that transformation which is being heralded is going to achieve social justice or not. And the Supreme Court had accepted many years ago that social justice is the signature tune of the Indian Constitution. Because, Indian Constitution was enacted to bring a change. It is an instrument of change. We were not looking for maintaining status quo. In some respects, status quo is to be maintained. We cannot abruptly make divorce from the past history. So for that matter, you know about Government of India Act 1935. That was incorporated in our Indian Constitution. But that dealt with only the functioning of the different organs of the society, of the state, barring judiciary. That was the only purpose, providing for governance, you can say. But now our constitution needed more than that. So in that sense, our constitution is purely an Indian contribution. No doubt that we have taken something and many things, you can say, from Government of India Act 1935. But then there are certain unique features also. Untouchability is abolished, you know. The Hindu temples of public character are open to all. And then we have Director of State Policy. And that is why, if you can recall, Granville Austin had called this Indian Constitution as a document of social revolution. It was social. It was to bring social revolution. And word revolution, if you don't want to use, then it can be social transformation. So that is about the Constitution. That our Indian Constitution is a break from the past. It is an instrument of social transformation. It is not to maintain a status quo. It has to brought about certain social change, but that social change is to be directed. It is to be informed by justice, that is social justice. And in the beginning of the Director of State Policy, it is written that the justice will inform all the institutions of life and state. So that was the basic purpose, that we will have social justice. Otherwise, a social transformation can go wayward. So there was a direction, that is social justice. For that, social transformation will take place. Another element which is specified in my topic is democracy. Now, loosely we can say that democracy is a kind of a process through which a collective decision making is made. That is, democracy is collective decision making process in which every individual is given equal say. If only few can speak, few can participate, that cannot be democracy. So we wanted to have that kind of democracy in which all the adults can participate. So from the very beginning, we started with adult franchise so that all can participate. So by democracy, our constitution means a set of collective decision-making processes in which those who belong to a particular group have an equal say in determining the rules that will govern them. Now, question arises, what do we understand by democracy? Now, democracy can be understood in two senses. One sense is that democracy is the intrinsic value of the society. It is intrinsic virtue. It is merit of the society. Because if you can recall, in ancient India, Shastrat, that is debate on Shastras, was allowed. So, democracy means that we give equal respect to all. So if you are in a class, if you are in your colony, if you listen to the words of your adults, your neighbors, and your friends, and give equal weightage to their opinions also, whether you accept or reject, but you think that they are allowed to speak, that is democracy. So when you allow other people also, you think they are also intelligent enough to give their opinion, that is democracy. And that is a virtue, that is part of dharma. So first thing is that it can be taken as intrinsic value of the society, virtue or value or merit. Second thing is that it should be taken as an instrument to bring social transformation in order to achieve social justice. As I have spoken just now, that our social transformation has to achieve social justice. But what will be the tool? What will be the instrument? how will we achieve it? Because that can be achieved in the non-democratic society also. But we never wanted that monarchy or dictatorship or totalitarian kind of society as was USSR, if you can recall. We wanted that it should be democratic society. So what is democracy? Democracy, number one, for us is a value, is a virtue, is a merit of the society. And secondly, it is an instrument of polity. The polity, that is the state will use democracy for bringing social change, social justice, and social transformation. Now, what is the problem with the democracy? Because there are many models. And when we were drafting our constitution, we adopted or favored, you can say, this parliamentary form of government. There were two models, competing models at that time. One was a presidential model that is operating, in the United States of America, and second was parliamentary model, still operational in United Kingdom. Now, we were very familiar with the parliamentary model, so we adopted for that, but that is not the only reason. In parliamentary model, the representatives are very close to the people. They are responsible, you can say. They are more representative in nature, because you elect MP, you elect MLAs. So they are very close to you people or us. They remain in our areas. And then we know it very well that if the government is not taking the parliament or the legislature, you can say, in confidence, then it will be removed. So that is why we went for that. But then Dr. Ambedkar, if you can recall his speech, when he talks about democracy, and he says that under the constitution, we are going to start with what we may call political democracy. But this political democracy is to be converted into social democracy, because parliamentary model has many good things and many bad things also. But if we are having only political democracy, then we cannot achieve social justice. We cannot have social transformation. So that's why he talks about constitutional morality, and he says that this political democracy is also to be converted into social democracy. That was his viewpoint. Now, what we have seen in democracy, that is one of the, demerits of modern times democracies, is that democracy in contemporary society is being taken as a political majoritarian equation. That is, in modern society, democracy is run through political parties. It is not the majority of the people which truly gets represented in parliament. Rather, it is the political party in power, or say in the majority of the members of the parliament, that matters. And moreover, the interests of different groups in political parties, they decide the course of action. That is the demerit of democracy. Nowadays, a majoritarian equation. So how to get rid of that? That is very essential, because you can very well understand that the political party in power may use democracy to hinder the ideal of social justice to be achieved, or it may pay just a lip service to it. So that means there may be some kind of conflict between democracy and social justice. So what is justice? What is justice? Before we decide social justice, but what is justice? By justice, we mean, that means our constitution means, because it in preamble, it is written that we are having democracy in this country to secure to its citizens justice, social, political, and economic justice. So democracy was an instrument, is an instrument to secure to its citizens justice, liberty, equality, fraternity, dignity. So in that sense, we can say democracy is an instrument to get justice. But what is justice? By justice, our constitution means a set of principles whose function is to distribute entitlements and valuable resources. That is distributive justice. It will distribute through justice. Through the principles of justice, the state will ensure that the entitlements and resources, valuable resources, are distributed equally. What are the resources? Or you may call common goods. They are liberties. Liberties are also resources. If you are free, that is a resource available to you. Opportunities, income, wealth, these are different resources and they are to be distributed among a plurality of agents who are competing. Plurality of agents here would mean different classes in India who are competing to get these resources. So the principles of justice will be fashioned in such a manner that it can answer the question. It's a very important question. Who is entitled to what? Who is entitled to what? That is relative to a particular set of people, fellow citizens in our case, who are competing over resources. They need to pursue their ends and goals. Why we compete? The people compete for having resources, liberties, why they need opportunities, why they need income, why they need wealth, because they want to pursue their ends and goals, personal goals, family goals, societal goals. For that, opportunity is necessary, income is necessary. So principles of justice would ensure that the resources are equally distributed. Now, a common response to these principles will be that it is better that if we give these most fundamental requirements of justice the status of constitutional rights. For example, untouchability is abolished. Article 14 talks about equality. Opportunities in Article 15, Clause 4, that is reservation in education institutions. Article 16 talks about reservation in government posts. And then there are certain rights which are given in our constitution, fundamental rights I am talking about, that these liberties, these opportunities, these resources, these things should be raised to the level of constitutional rights or fundamental rights or Bill of Rights. If we raise them to that level, and that has been done under the Indian Constitution also, so in that way they are removed from the democratic process. Now, untouchability is not subject to democratic process. You know about other rights also, they have been taken away, they have been removed from democratic process. For example, we can talk about right to education. Right to education, to start with, in 1949, it was just a directive principle of state policy. And it was written in Article 45, that is a directive principle of state policy, that the state shall try to secure free and compulsory education to the children below 14 years. That was a kind of a directive principle. That was a direction. And it was expected that the state, that includes all the state governments, would do enough to bring free and compulsory education to all the children who are below 14 years. It didn't happen. It didn't happen. We got this constitution in 1950. For 4 decades, nothing happened. So what the Supreme Court did, Supreme Court removed it from directive principle of state policy to fundamental right under Article 21. Article 21 says right to life and liberty. So right to life was already there. So the Supreme Court came to the conclusion that, what has happened here? Am I audible? Oh yeah.
Yes, sir.
Okay. So what the Supreme Court did, that it read right to education in Article 21. And in that way, it was removed from the parliamentary process because nothing had happened in 40 years. So the basic needs which we require, and these are the elements of social justice: food, shelter, education, medicines. All of them have been removed from Directive Principles of State Policy and have been brought in the chapter on fundamental rights. So that means if we want to achieve justice, social justice, one strand of thinking, it's not all, one strand of thinking is that there is a tension between democracy and justice, or democracy and social justice. Because in the Mediterranean, where majority rules, where the majority is ruled by interest, the interests of different groups, maybe capitalists, maybe big farmers, maybe big people, they pass the laws which favor them. So social justice is given only a lip service. For example, right to education. It was very essential. So what is the way out? Remove all these basic needs of justice from democratic process. And that has happened. So in a way, we can say liberty, equality, and subsistence rights on which we can, survive. Those rights, they place constraints on democratic decision-making process. And I'm talking about it because the title of my address, which has been given by the organizers, is to have democracy and social justice also. So this is one way of looking at the tension between democracy and social justice. So on this account, democracy is instrumental to justice. So what is democracy? Democracy is an implementation mechanism that is to be used. But if it is not useful, then those rights can be upwarded to the level of what you may call fundamental rights. Now, Ronald Dworkin, I would like to rope in at this point of time. He says, now he's defending democracy. Why? Because if the people are well aware and they are participating in the democratic process, then there is more likelihood of having that distribution of material resources. He says, he argues, and in his words, democracy is to be valued because a community in which the vote is widely held, number one, vote is widely held and speech is free. Two things. If in a society, vote is widely held. In India, vote is widely held. Widely held means there is adult franchise. All adults above 18, they can vote. And speech is free. It is doubtful nowadays, but nevertheless, under Article 19, Clause 1, Subclause A, it is free. So he says that in a community in which the vote is widely held, is available to a large section of the society, and there is right to speech also, free speech, it is more likely that society, that community is more likely to distribute material resources and other opportunities and values in an egalitarian way. So we cannot shun away that democracy is useless. No, democracy is useful. In India, we have adult franchise and we have freedom of speech and expression also, despite there are certain onslaughts in recent times. It has value. That means that, excuse me, we go back to our constitution again now, because I have discussed about constitution, then democracy, and then justice. Now we look at our constitution. As you know, I discussed it, that the process of constitution making started, you can say, with the Motilal Nehru report also. And then I talked about Granville Austin quotation also, that it is an agenda for social revolution. But another thing which is added in your this online certificate course is, that is contemporary issues. What are the contemporary issues? Now we should look at that also, because I talked about the jurisprudential aspects of all these things, but now we have to talk about the contemporary issues. One very interesting thing has happened in recent times. We were very comfortable with and are comfortable with basic structure theory that was propounded in Keshwanand Bharati case, where in 1973 the Supreme Court declared that the Parliament cannot amend all the features of the Constitution. There is a basic structure which cannot be destroyed. We know that it is not written in the Constitution, but Constitution is not only written rules. A good part of Constitution is beyond Constitution or beyond constitutional document, that is piece of paper. And from there it was found that this document called called Constitution of India is based on a structure, that is basic structure. And basic structure cannot be destroyed. If it is destroyed, then this document known as Constitution of India will crumble down. Therefore, a limitation was put on the democratic process, on Parliament, that you cannot remove, destroy basic structure. Now, what has happened in recent times, that the question is whether basic structure doctrine, it puts limit on the dance of democracy. Yes. Contemporary thinking is like that, because we know that some doubts have recently been raised. By whom? By the representatives of the people. Even Vice President of India also. Many legislator parliamentarians also. Former law minister also. And they have raised doubts over the correctness of basic structure theory. This is a contemporary issue which I see, that basic structure is a kind of a restriction on democracy. Democracy cannot be fully free. In India, we have a constitutional democracy. And in constitutional democracy, democracy is to be regulated by the Constitution. And what is the Constitution? The Constitution is what the Supreme Court says it is. I cannot say it is Constitution. The Parliament cannot say it is the meaning of the Constitution. Some well-trained people And it has been accepted that the judges are well trained in legal things, because constitution is for us a social document, for us it is a political document, for us it is economic document, but we cannot forget it, that it is a legal document also. So who can interpret it? Who will have the final say on the interpretation of the constitution? The judges, the Supreme Court judges, you can say. And they found that under this constitution, Supreme Court has been created and Parliament has also been created. So Parliament is the creation of constitution. So how Parliament can change the constitution without any kind of limitations? So there are implied limitations. So in a way we can say constitution restricted the full play of democracy. It's not like Switzerland democracy. We have a different kind of democracy here. So the most important thing, contemporary issue, there are many, but I can't take all of them right now. So this is one thing, because it is directly related to my topic, which has been given by the organizers, that is democracy, constitution, and social justice. So democracy versus constitution. So this is reflected in the basic structure doctrine. Then another thing which I can take, that is in the light of, if you can recall, three farm laws. Three farm laws, they were repealed. And there was, I think, for more than 9 months, if I can say so, there was a protest in and around Delhi. And they were sitting there, the farmers were sitting there. Now, in the light of these three farm laws, which were afterwards repealed, but they were drafted in Parliament without any debate. If you can recall, the former Chief Justice of India, Honorable Justice Ramanna, had said that the bills are being passed as laws, naturally, without adequate debate. The opposition parties had also raised their voice. But what is this? That you do not allow full debate on this bill. So likewise, three farm laws also came like a bolt from the blue. All of a sudden they were promulgated and they were passed in Parliament without any public debate. There could have been a public debate on that, but that was not there. So in the light of these three farm laws, we have certain concerns for this social justice and democracy also. For democracy, because not much of debate had taken place on this. Now we come to these three farm laws. Now we know it, that the directive principles of state policy, they contain the provisions of social justice. But what had happened in the beginning, after independence in 1950, after 1950, when we started with this constitution, we see that the Parliament had enacted laws to implement the agrarian reforms. Kerala has a very good record of land reforms, agrarian reforms. And likewise, West Bengal also has that good record, unlike Bihar and Uttar Pradesh. And just after independence, that is in 1947, the laws were passed in 48, 49, and 50, 52 also. So what we see, that when these laws were enacted by Parliament and state legislatures to implement the agrarian reforms, the right to property, it was a fundamental right under Article 31, was advocated to hinder the social justice. Because one of the directive principles of state policy is under Article 39B and 39C, taken together, that the material resources of the country will be used for common good, and the concentration of wealth and resources in few hands will not be allowed. That the state will, in other words, the state will try to use the material resources for common good for all, and it will not allow the material resources to be concentrated, to be confined in few hands. Because when we became free in 1947, large pieces of lands were occupied by zamindars. Even they were having lakes, ponds, small rivers, forests, mines, coal mines, iron mines. All these were in private hands. And what is justice? I discussed it just now. The justice demands, or rather the principles of justice set that the resources of the country, material resources of the society or community, are distributed among all. So for that, directive principle of state policy was there. So in order to implement these directive principles of state policy, the state legislature enacted many laws, and they were challenged in the court of law. And the Supreme Court struck down many of them. On what basis? That they violate right to equality, because only certain zamindars were being affected. Article 31, that was a fundamental right to property. Without compensation, you cannot take. That was another. Then there was Article 19 also, which also included right to property. And 21 also in some respects. So they violated the fundamental rights. And fundamental rights are justiciable. Directive principles are not justiciable. This was the ground. And therefore, fundamental rights cannot override the directive principle state policy. Therefore, these laws, agrarian reform laws, land reform laws, are unconstitutional. Side by side, another thing had also happened, that in order to provide opportunities in educational institutions and in governmental posts, reservations were also made. And you are law students, you know about Champakam Dorai case. The first case on reservation, where the state of Madras for a long time, since 1927, was providing for reservation in educational institutions and posts on the basis of caste and communities. This was challenged after 1950. That is on the ground that it comes in conflict with fundamental right. It was also struck down. But I am coming back to three farm laws, that is agrarian reforms and land reforms laws. Now, when they were struck down, that what happened? Parliament amended the constitution. The first amendment was to come over the difficulties, to overcome the difficulties created by the interpretation of the Supreme Court. And the first amendment amended the fundamental right, that is right to property. This is the dance of democracy. That happened in 1950s, not now. Now we see three farm laws. So in 1950s, the first amendment circumscribed 31 and 19 also. We will not go into that, only 31. So by that, land reforms were secured. And not only this, a novel thing happened which had not happened in any other constitutional system. A schedule was added, 9th schedule. And all these laws, agrarian reform laws, zamindari abolition laws, land reform laws, were put in 9th schedule. And it was provided that the laws which have been put in 9th schedule are away from judicial review. So they were not within the jurisdiction of the Supreme Court. But what has happened now? In contemporary times, these 3 farm laws attempted to turn the table by privatization, imposing capitalist structure, and they had to be withdrawn because of the democratic protest by the farmers. So that means the constitution gains its meaning through democratic process also. One way of looking in the beginning, when I was talking about democracy and justice, one way of looking at the relationship between democracy and justice was that in majoritarian democracy, justice may be sacrificed because those majoritarian classes, groups, political parties, they try to favor the interest of their supporters, classes. But now we see that even if they pass laws without debate, having overwhelming majority in the parliament, the democratic protest or processes can force them to overturn, to repeal those laws also. This is a wonderful change which we have seen in recent times. Then how democratic process was strengthened by parliament also. We see both the sides. Parliament in the initial stages provided for first amendment, gave 9th schedule and brought all the laws in the 9th schedule, removing them from judicial review. We see then in recent times 3 farm laws also being made, which go against the spirit of the constitution, social justice, if I can say so. Parliament enacting it, then parliament doing good things also. For example, if you can recall, though it is not that much contemporary, but it is very essential, because I talked about Ronald Dworkin when he says that if right to vote is widely held, it is available to most of the people. So if you can recall, a constitutional amendment lowered the voting age from 21 years to 18 years. From 21 years to 18 years. And it was done in order to bring more and more people in the net of voting and to broad base the democratic process. It has been done by parliament. And then if you can again recall, the 73rd and 74th amendment, in order to strengthen the grassroots democracy, that is panchayati level, the 73rd and 74th amendments made the panchayati raj, or you can call it local self-governance, possible at the district level and made it a significant component of the Indian democracy. As we know, village republics was a non-justiciable goal in directive principles of state policy. That is village republic, because there was a debate in parliament. Dr. Ambedkar was against this village republic system because his viewpoint was that the villages are dens of localism and casteism. And to a great extent, he is right. He was right. But now the things had changed because decentralization process had started. And when you are talking about social justice, how sitting in Delhi or sitting in the capital, you can know what are the requirements of justice of the people living at the grassroots level. So for that, it was necessary that the governance should be brought near them so that the principles of justice can also be set at the local level. So village republics was a non-justiciable goal in directive principles, but even then, now it has become a constitutional goal through the two amendments, that is strengthening democracy for social justice, for bringing social transformation. Then in recent times, women reservation bill, those law. Now your constitutional amendment has been brought for providing women reservation in parliament, in Lok Sabha, and in state legislatures also. There may be some political reasons for that. But the point is that this was a long-standing demand, that the women were not being represented there. And it has been provided. But still a long way we have to chart out, because there are some voices which are concerned with the representation of women through OBCs and SCs and STs also. As you see in case of EWS, economically weaker sections. Now EWS is confined in admissions and in post is confined only to general category. So why not to OBCs and SCs and STs also? And this churning is going on in Bihar. They have taken the caste survey, but those are the political issue. I would not go into that. So what I wanted to share with you was, what is democracy? Can democracy come in conflict with justice? Can justice be a lodestar of constitution? Parliament doing good for justice, Parliament not doing good for justice? Supreme Court in the initial stages settling down all the social justice provisions, Champakam Horizon and land reforms law, and then changing. We cannot go into that, but if time permits, I don't know how much time I am left with. About the Supreme Court, I can speak for few minutes.
Yes, sir.
So, for example, you take, I will just read it in SMS language. A Bandhua Mukti Morcha case, a laudable case decided in 1984. The bonded labor were not enjoying right to life. And if you are in bondage, despite Article 23, right against exploitation is a fundamental right. Even then, nothing was happening. So the Supreme Court came to their rescue, and they were released through that judicial decision given by the Supreme Court in 1984. Then Vishakha case, you know about that. And how can it come in social justice or social transformation? Because if a woman is not in a position to earn her livelihood, she is discriminated at the workplace because she is a woman, then is it justice? Social justice means distribution of resources. So she is going to earn income, wealth, opportunities. All are denied because of sexual harassment. So that is also a case, laudable case. Then you know about Paschim Bang Khet Mazdoor Samiti case, where timely medical treatment is necessary, because education and health, these are two small but very important components of justice. They have to be provided. Then MC Mehta case, if you can recall, started from 1987. Pollution-free environment. If I cannot inhale pure air, my productivity will go down, and I will not be in a position to earn my livelihood. And then I cannot secure the opportunities which come my way. Directly related. Then right to education. I discussed it. Moni Jain came in 1992. In 1992, and then Unni Krishnan. In both the cases, it was decided that right to education is a fundamental right. And the beauty of this judgment is that a fundamental right was added in Article 21. That was possible because of the Supreme Court decision, because this was realized by the democratic process also, that this has to be added. So Constitution was amended. So I have discussed all these things now. I think my time is over, but it will be better if you ask question so that other things can be discussed in question answer session. Thank you.
Professor Bhatnagar, sir, there are a few questions in the chat box. May I read it?
If you think 2 or 3 questions can be taken together,
Okay.
so you can make a group.
Okay.
You may have your own time, 2-3 minutes.
The first one is law is not static but dynamic in nature. It will change according to the changing needs of the society. Can we say this is social transformation? And second one is why right to property has been made as fundamental right initially, and what are the actual reason it has been diluted to mere legal rights? These are the two.
What was the first question is?
First question is, there is a quote that is, law is not static, but dynamic in nature.
Right,
It
right.
will change according to the changing needs of the society.
Right.
Can we say this is social transformation? That is
Okay.
from Blessing. Blessing has asked this question.
Okay. So law is never static. The point is, what is constitution? Now, identity of constitution in 1950 has changed. Why? Because our understanding of constitution also gets improved. If she is a law student, she must be knowing that in 1967, the Supreme Court declared the fundamental rights cannot be amended. Just after 6 years, in 1973, Supreme Court says fundamental rights can be amended. That is 65, fundamental rights can be amended. Sajjan Singh. 67, 2 years after that, Golaknath, fundamental rights cannot be amended. 73, 6 years after that, fundamental rights can be amended. So from 65 to 73, within 8 years, the Supreme Court changes its stand. Why? Because the needs of the society were changing, number one. Number two, that our understanding is also getting improved. Golak, you know about A.K. Gopalan case, then Menka Gandhi case comes. In the initial stages, we were not aware of the reach of Article 21. Nobody knew about public interest litigation, PIL. But after 1978, after Menka Gandhi case, we have PIL. We have new understanding of Article 32. We have new understanding of Article 21, right to life. So as we grow, our understanding grows. And not only the common people of India, even the Supreme Court judges, they also get enlightened. And they are always prepared to correct themselves. So law is never static. It is dynamic. And about the Constitution, you must know that it is known as a living tree. It is an organism. It is keeping pace with the needs of the people. It is taking into account the global changes also. Vishakha case was based on certain global changes. So it is taken in all the kinds of changes, needs, requirements. So nothing can remain static. You know, the relationship between parents and children have changed. When I was a child, I used to look towards the mood of my father. And now I look towards the mood of my son. So for me, it is the same game. But for others, you know, the things have changed. So the relationship between wife and husband has changed. Needs have changed. Document has changed. And you know, what is permanent? Change. Change is constant. So law, rules, morality, ethics, they are never constant. They are never frozen. They keep on changing. Now, what is second question? Am I able to satisfy?
Second question is regarding right to property. Why right to property has been made as fundamental right initially, and then it has been diluted.
Okay, in 1913, a book was written by an American author, Beard. He had written a book, An Economic Interpretation of the American Constitution. Title may be somewhat different. That was an economic interpretation of the US Constitution. And that book he has written that the framers of the American Constitution were basically merchants and big landlords. So they kept their economic interest on top. That is why in the USA, when this constitution was drafted, slavery was continued. After 90 years, slavery was abolished. Now, coming to Indian constitution, I will not make that charge which that Charles Beard makes against the framers of the American Constitution. But I would say that what was the composition of our Constituent Assembly? There were more than 90 princely states, representatives of princely states. Big landlords were there. That was unelected. And who can go up to the political ladder? Only those who were resourceful. So I am not charging anything. Right to property was a fundamental right in other constitutions also. That is why they copied it and they brought it there. But very interestingly, in 1950, we have a constitution which gives absolute right to property. And 1951, 1 year after that, the same framers, they were sitting as a parliament, provincial parliament, because the first parliament came in 1952. They tweaked Article 31 to bring social justice, to bring land reforms, because this was realized by them that a mistake has been made. So that is why it was tweaked. Then till 1978, it was realized that the right to property cannot remain as fundamental right. That is why it was removed from 31 and made a constitutional right in 300A. That happened in 1978. After that, you come to 2013. In 2013, it was realized that this is there a constitutional right, but that land acquisition law of British period was very torturous for farmers and for landowners. So right to fair compensation and transparency in acquisition, Rehabilitation and Resettlement Act 2013 was passed. And by that it is provided that the compensation has to be given, and there are many things also. So we have come to that level, and now people are demanding that even the Act of 2013 should be amended so that the land can be taken easily, because there are so many constraints. So this is the history, and history of the people of parliament. They change and their perspectives also change. Okay.
Just one more question, that is,
Yeah, sure, please go ahead.
Why it has been said that fundamental rights and directive principles are supplementary and complementary to each other?
Okay. Initially, it was thought that they come in conflict with one another. But after Keshwaran Bharti case, then you come to Minerva Mills case, it has been realized that one may be taken as a stream and another may be taken as banks. That is, both of them come together. They go together. They supplement and complement, because some of the fundamental rights, very important fundamental rights, human rights, they have been made fundamental rights. Directive principles of state of policy are also rights. but they were fundamental in governance, but they were not to be operated through the court of law. That is the basic difference. Because I don't have much time, but I can tell you one thing, that what can be done, that if there were many rights, some rights, human rights I am talking about them, were converted into fundamental rights, and other were converted into directive state policy. So right to religion was made fundamental right. We made a mistake that right to education was made a directive principle of state policy, and that was converted into a fundamental right. So they belong to same genus, that is human rights. Species are different, and there can be an interflow of elements also. Even fundamental rights can be interpreted in the light of directive principle state policy. That can be done. Yes, please.
So there is a question from Ali Moon. So the session was very insightful. If the time permits, can you, you said about the correctness of basic structure doctrine. Specifically, if the winds are against basic structure doctrine, how would it affect the fundamental rights in a political democracy, which leans more towards capitalistic tendencies, learning reasoned issues? Ali, do you want to raise a question yourself? Ali?
Please ask her. Please ask.
Ali Moon, are you there?
Him. Sorry.
Ali Moon, can you hear me? Okay, so I'll just read it once again. I think it's not it. The correctness you said about the correctness of the basic structure doctrine. Specifically, if the winds are against the basic structure doctrine, how would it affect the fundamental rights in a political democracy, which leans more towards capitalistic tendencies, learning recent issues?
Which issues?
Learning the recent issues.
Okay, right. Now, first thing is that there seems to be a conflict when this basic structure doctrine is being doubted. It is a unique case of conflict between Parliament and Supreme Court. That happened in 1973 also. In 1973, Golaknath case was overruled, which had provided that the fundamental rights cannot be amended. But the Supreme Court gave a kind of a leeway to Parliament by saying that fundamental rights can be amended. But it was a big rider, but the basic structure cannot be destroyed. Now, Parliament says, or even if the Vice President says, who is the chairman of Rajya Sabha, the law minister had said that this basic structure doctrine is incorrect. Now, what is basic structure doctrine? It is an interpretation of the Indian Constitution to say that there are certain implied limitations which cannot be read into or which cannot be reflected in the rules. But Constitution is based not only on the written rules, it is based on principles. So what is reflected in 368, Article 368, is a tip of iceberg. 1/10 of power to amend the Constitution is reflected by reading Article 368. But Article 368 does not incorporate whole of the amending power of the Constitution, because 368 reflects the rules, and the amending rules are based on amending principles, certain basic moral and political theory. So this Constitution is based on some moral and political theory. As Ronald Dawkins says, that if there are hard cases, and Keshwanand Bharti case was a hard case, there the rules will not give adequate answers, sometimes even not the right answers. Then you have to look beyond the written words. And when you are looking beyond the written words, it does not mean that you go astray. It means that you look to the moorings, the roots of the Constitution. And in the roots of the Constitution, you will find that there are certain principles. So that is why he makes a distinction between rules and principles. Rules can change. Principles cannot be changed. So the parliament changed Article 368. If you can recall, 42nd Amendment, before that 39th, 25th, 24th Amendment, these were challenged in Keshwanand Bharti case. And then 42nd Amendment, that is a different story. So by amendment, parliament changes the rules. But the rules cannot go against the principles. Now those principles are to be discovered. How they can be discovered? Principles. The principles of interpretation are to be principles of constitutions. Underlying principles of the constitution can be discovered through judicial training, legal minds, judicial minds. And they have found that there is a basic structure which cannot be destroyed by parliament, because the parliament is the creation of the constitution. This parliament has not created the constitution. Constitution has created the parliament. So it cannot say, parliament cannot say the limitations, implied limitations which were put on our powers, we will first remove them, as was done in Article 68, and then we will amend the constitution. This is one thing. Second thing is what, if you can recall, Lord Denning once said that we have to believe somebody. You know, when we are kids, we believe in the power of father or mother. And if you can recall, there used to be one advertisement, my father is strongest. He can do anything. We believe, we have faith in father. So in society, in community, whether the punches or those wise people or the elderly people, we believe them. So Lord Denning says, we have to believe somebody. Let us believe judges. So I belong to that category, that the justice is a very special kind of inquiry. Democracy is a very special kind of inquiry. What are the principles, moral principles? Moral reading of the constitution is to be done. What are the political principles, political morality underlying? This is to be understood, and that can be understood by specialists. Judges are specialists. They are not elected. That is a good thing. That is because they are not looking towards next election. You know, American judges never retire. There is no age of retirement. Why? Because they have to be believed. We have an age of retirement, that's a different thing. But coming back to that we have to believe that the judges can interpret this constitution. So I am in favor of basic structure doctrine, and those who want to, bring it down and create doubts about it, they have some other things, because they will always do that. Majoritarian democracy or majoritarian equation would never like limitations, and that is why Supreme Court or court is counter majoritarian. It should be there. If opposition is not there, Supreme Court is there, but Supreme Court is not opposing. It is only reading the constitution. Thank you. Any other question, please?
No, sir. There isn't any more questions in the chat box. If any one of the participants have to share their questions or any clarifications.
Hello, sir. Good evening, sir. I am having one question. My name is
Please,
Bijoy.
Vijay.
Sir,
Yeah.
sir, whether this basic structure will be a limitation when we consider our future after maybe 100 years, since the basic structure is a limitation to the parliament, so whether it will affect our dynamism of the constitution?
Now, when this Keshwaran Bharti case was being argued, so this question was raised that if Parliament passes a law by which the term of Lok Sabha is increased from 5 years to 99 years. And if you can recall, by 42nd Amendment, it was, extended from 5 years to 6 years in certain situations. So if Parliament chooses to pass a law or amendment, that the period of tenure of Lok Sabha will not be 5 years, it will be 99 years. Then there is no need of going for election in public. These Lok Sabha members will elect its own members if anyone dies. So whether that can be accepted, that is the basic question. So basic structure doctrine is a limitation on the powers of Parliament so long as we go ahead with this constitution. If we want to change the scene or situation, we will have to throw this constitution in the dustbin, and constitutions have been thrown in the dustbin also. That is possible. But this constitution will not allow its own amendment in violation of its own basic structure. This is my response.
Thank you, sir. But sir, one thing, when
Yeah.
we consider the National Judicial Commission,
Mhm.
the decision by Supreme Court is creating some limitation to Parliament.
There are certain black spots also. Even Moon has certain spots. Even American Supreme Court had black spots when it allowed slavery, when it allowed separate but equal, when it allowed that black people cannot take admission in white schools. That was not a good thing. So for me, this decision is also not a good thing. And no institution can be 100% correct. Supreme Court judges are human beings. And in realist movement, we study that aspect also. They are not robo. Even robo also commit mistakes. Even if we have AI, artificial intelligence, we are debating the legal responsibility if AI goes wrong. So it has happened, and it should not have happened. Even then, we are secure with them. Thank you.
Okay, thank you very much, sir. Thank you. This is a very good, excellent lecture, sir. Thank you very much, sir.
Are there any more other questions?
Actually, I had given more than 30 minutes for questions because I thought because everything cannot be encompassed in this lecture, and I knew that many issues have been left out. I could take only 2 or 3 issues because the topic was very broad. It was to bring justice and democracy together within the constitution. Very interesting topic.
So I don't think there are any more questions or queries. So with all our due respects, I would like to express our sincere gratitude to Professor S.K. Bhatnagar, sir, for rendering the valedictory address. And actually, sir, it was a very refreshing and unlearning experience for each one of us. We can go and just rethink once again all these fundamentals with the contemporary issues that is going on. Thank you so much, sir. Thank you very much.
Thank you. Thank you very much for inviting me and giving me this opportunity. Thank you. Thank you a lot to all the participants. Thank you. Bye-bye.
Thank you, all the esteemed participants, for joining us in this online short-term program on law and social transformation, contemporary issues. You have contributed and you have enriched, you have made this journey of 13 days academically a fruitful one. I appreciate the time and effort that you have taken. The Department of Lifelong Learning and Extension and the UGC Stride family hope that each one of you have enjoyed these 13-day sessions. I have to particularly thank the students of School of Indian Legal Thought, the first semester students of Indian Legal Thought, especially because it was their active involvement, it was their demand and request, and that ended up in this particular short-term program. So it actually, it is their effort, and they have been coordinating this program very well. So the first semester LLM students, the second and the final year LLM students were also there. So I thank the first semester LLM students for their active participation, and all the researchers and LLM students of School of Indian Legal Thought for that the support. I also like to thank Professor Dr. A.P. Rajesh, Professor of School of Indian Legal Thought, Dr. Jasmine Alex, School of Indian Legal Thought, for continuously being with us and supporting us. We would also like to thank, there are many, we thank each one of the participants. Though we are a large family of 402, I express my gratitude to each one of you for joining this particular program. And a special thanks to Dr. Girish Casey of Karnataka Law University, Dr. Subbalakshmi of SDM College, Dr. Subbalakshmi of Pondicherry University, Dr. Pearl Ma'am from Salgokar, Goa, Ria Raymol I, then Rupa CS from BOS Aluva, Sanjay Jha, Shiba Verghese, then definitely Hegin Han for those lovely questions, very thought-provoking questions. So I have to mention each one of you, but I'm just quickly mentioning a few names. So thank you one and all. We hope that you enjoyed. I thank the staff and students of Department of Lifelong Learning for continuously working throughout these 13 days. Actually, the entire staff and students leave the department only at by 10:30 in the night after editing the videos, etc., so that we can share it in the group the very next day. And we value your support and look forward to see you in the future events. Thank you so much. Thank you, one.